Hey, greetings, and welcome back to Categorical Imperatives. I am your host, Lockie and Liberal. Thank you for joining me here today. For those of you who are new, this is a podcast where we will be using legal and moral philosophy to discuss current events as they relate to various aspects of politics and culture. And today, I think we have a really good episode. I'm sure for those of you who tune in more regularly, you are expecting part three of my series on the Second Amendment and original intent versus original meaning, and that will be coming next in a couple days. But I was over in the 10th Amendment Center, uh, their show Path to Liberty the other day, which is a great show. If anyone who out there who isn't familiar with it should go check it out, they're fantastic. Uh, but in the chat, I had a very interesting question come up uh, from a user who was asking about how it is exactly that we've gotten, or how did we get to a place where what was our really fundamental natural right to privacy, how we got from that concept to the point of law where we see it protected in our Bill of Rights, mostly protected under the Fourth Amendment, and that was a really interesting topic, and what I'm really looking forward to talking with you guys about. So I wanted to get that one out of the way here before I finish up with the other series. Yeah, thank you to Tyler from over at Path to Liberty show for recommending this topic. I hope that you will all enjoy hearing it as much as I'm sure I am going to enjoy making it. Real quick, first of all, just some house cleaning here. I wanted to ask you guys. I'm really trying to switch over here now from doing the show specifically over on YouTube, where I can take advantage of a lot of the stuff I can do with video as well as audio. So while I'm still uploading at the time to the audio podcast places that I have always uploaded to in the past, I'm really looking to make a transfer over from those entirely to YouTube. I The direction I want to take the show in, it just seems like uh, an audio only podcast. It really won't transfer over with what I'm hopefully kind of planning to do here going forward. So if that's where you listen to me, I would ask maybe if you take a minute to pop on over to YouTube real quick. YouTube.com/users Reverend Bob 23. That's REVERENDBOB 23. And consider subscribing to the channel over there. And I would ask that if you hear the show today and you like it and you think it's interesting, would ask that you, at the end of this, share the episode with just one person who you think might enjoy hearing this message. Yeah. Anyways, with that, let's get on with the show. So, just to start out here, the Fourth Amendment says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated, and no warrant shall issue but upon probable cause supported by oath or affirmation, and particularly describing the place to be searched and the person or things to be seized. Now, this is a really fascinating topic for a number of reasons. I think first and foremost is because uh, I can't think of any other aspect, certainly of the Bill of Rights, and maybe even as the Constitution as a whole, where what we ended up with on paper could be more directly correlated with the experiences the founders had during the period leading up to the Revolutionary War, that were the causes that impelled them to separate from Great Britain in the first place. The second reason that I really want to do the show is because it's going to give me a chance to talk about James Otis. You guys who have been listening to the show know that one of my favorite things to do is to shed a little light on founding fathers that nobody knows and everybody absolutely should. We've recently done like Tench Cox, Roger Sherman, St. George Tucker, and James Otis is certainly right up there with them as far as important, but unfortunately underknown founders. And really, Otis was, I think you could arguably call him the father of the Fourth Amendment. And as if that isn't enough, he's also the person who is supposedly sparked, uh, sort of in John Adams, the sort of initial sense of a need for a revolution. We will get around to that in a second, though. Oh yeah, also, if all of that isn't enough, he is the guy who coined the phrase "no taxation without representation."
I don't know how to put this, but I'm kind of a big deal.
He is indeed kind of a big deal. And finally, what I really hope to share with you guys here is how the history of the right to privacy is seen through, especially this particular lens of natural law, natural rights, and the common law, can help dispel what I think is one of the most pernicious myths right now about the Fourth Amendment that exists today. Uh, and this has been caused by our general inclination to define the rights that we have that are in the Constitution as strictly being constitutional rights, as though these are things that just suddenly came into being in 1791 without any sort of antecedent whatsoever. And I think it's because of this kind of view that we have a Fourth Amendment nowadays. The modern notion of the Fourth Amendment is really almost assumed to be an obstacle to overzealous police power that is defined strictly through a whole series of legal tests surrounding substantive due process and procedural law, when really that is not at all what the purpose of the Fourth Amendment was meant to accomplish. So we will be getting into all of that here. And let's start there, actually. So, what answer can originalism, common law, natural rights all provide in understanding the Fourth Amendment uh, in its proper context? Really, the answer to this question is innumerable, but I think a good place to start is why are we in such a mess answering that question today? And really, when we look at the Fourth Amendment, as it relates to constitutional law, I think what we really find is uh, almost a nonsensical sort of set of applied standards, various contradictory doctrines, and that all really sort of depend not on the law so much as on judicial predilection. And I think the failure to adhere to the original meaning of the Fourth Amendment and the right to privacy has also played a huge role in undermining both the First Amendment and the Fifth Amendment in certain contexts as well. Uh, the founders wrote the Fourth Amendment to secure liberty. That clause restricted government power and reinforced the right of the people as the sovereign to determine the condition under which the government could interfere in the privacies of life. So, the proper way to understand the Fourth Amendment is first as a prohibition on promiscuous search and seizure, and as a requirement for specificity in the warrants that are then granted. Now, when we turn to 17th and 18th century legal treatises, we find jurists taking the position that outside of a very narrow set of circumstances, which are namely the hue and cry and the fleeing felon exception, that the government could not enter into anybody's home without a warrant and without specificity. Uh, Specifically, we're talking about the issuance of general warrants. General warrants, just so we're all kind of on the same page here, are basically documents issued by the court or by the executive branch which give officials the authority to enter into a home or to search for private documents or to seize them without prior evidence of wrongdoing, without specifying with particularity the places to be searched and the persons or papers to be seized. It is not supported by oath or affirmation of wrongdoing, and generally will amount to a fishing expedition, where they are instead trying to find evidence of wrongdoing rather than acting on evidence of wrongdoing. So, this is why, for centuries prior to the American founding, when we turn to English treatises and jurists, we see time and again that they reject the idea of a general warrant, often referring to it as the worst exercise of tyrannical power. And a good place to start looking at some of that is with Semayne's case in 1604. As you can see, Semayne's case is an Old English common law case which held that the right of a homeowner to defend his or her premises against intrusion should yield to those seeking to enter under lawful authority, like to make an arrest. This case was reported by Sir Edward Coke, who was the then Attorney General of England, and the case is famous for Cook's quote that, quote, "The house of everyone is to him as his castle and fortress, as well for his defense against injury and violence as for his repose." And in the US, this case is generally recognized as establishing what we now call the knock and announce rule. Next is Entick v. Carrington, case from 1765. And this case is a leading case in English law and UK constitutional law establishing the civil liberties of individuals and limiting the scope of executive power. This case has also been influential in other common law jurisdictions and was an important motivation for the Fourth Amendment of the United States Constitution. And a famous dictum that came from this case came from Lord Camden when he said, quote, "If it is law, it will be found in our books. If it is not to be found there, it is not law." Moving on, there is another case too that is Money v. Leach. This is from 1765, and this was a case that held that a general warrant to seize some person not named in the warrant is illegal. And the jurists rejected the Crown's efforts to use general warrants. As Charles Pratt, the Chief Justice of the Common Pleas, explained in the case of Entick v. Carrington, the law denied the Crown the authority to enter a subject's domiciles at will. Every invasion of private property, be ever so minute, is still a trespass. The protection in this case extended to letters and documents and papers of individuals, and every man was entitled to live free from the gaze of the Crown. Thus it had been since 1604 in Semayne's case. And again, we have Cook's quote that the house of everyone is to him as his castle and fortress, as well as his defense against injury and violence as for his repose. Uh, he further went on to say that general warrants were outside of the common law because they retained for the crown the particulars of suspicion, and by using general warrants, the crown did not have to provide evidence in open court. So the issues went to rule of law as a constraint on government power. And this is where we see degradation of the Fourth Amendment, sort of tie into the degradation of the Fifth Amendment. It essentially this issuance as rule of law it comes from the Fifth Amendment's due process clause. So as uh, the Fourth Amendment right of certain seizure has corroded, so too automatically we have to see the due process clause of the Fifth, and I suppose really actually 14th amendments as well, just as a natural consequence. And William Pitt actually put this in even more colorful language when he said, "Oh, excuse me." When he said, "The poorest man may in his cottage bid defiance to all the force of the crown. It may be frail, its roof may shake, its wind may blow, but through it the storm may not enter, the rain may enter, but the King of England cannot enter. All his forces dare not cross the threshold of the ruined tenement. And we have another case as well here, Wilkes v. Wood from 1763. And this established the principle that general warrants are normally illegal. The government cannot simply give the police the authority to search a person's possessions in hopes of finding incriminating evidence. This warrant must specify what government authorities believe they will find and where. And in this case, the remedy that Wilkes was able to obtain was a substantial monetary damage, but more importantly, this really created the exclusionary rule that did not exist prior to 1763. And these concepts are things that we also see reinforced by other famous English jurists, such as Sir Matthew Hale's treatise Historia Placitorum Coronae and William Blackstone's commentaries on the common laws of England. And so now we get to James Otis. So James Otis's fiery oration in what was known as the Paxton case uh, explained that the founders, when they left England, had expected their rights as Englishmen to follow with them. But in fact, they had not, and the writs of assistance had proliferated. James Otis referred to them as the worst exercise of arbitrary power and the most destructive of English liberty that was ever found in an English law book. At its base was the need to restrain that government power. And so this is why when Virginia, Pennsylvania, Delaware, Maryland, and North Carolina all crafted their state constitutions, all of them outlawed general warrants. And as the Articles of Confederation became the Constitution, so too did the founding generation insist that there must be this prohibition on general warrants. Outside of a particularized warrant that meets the requirement of the Fourth Amendment, or a fleeing felon in flight, or the hue and cry, historically, the government could not enter. And not only could they not enter, but the government for nearly 200 years couldn't obtain private papers. This means that an originalist reading of the Fourth Amendment is not, as is widely considered today, uh, an obstacle to prevent too much permeating police power of surveillance. Instead, it is a restriction on government power that forbids access to intimate details outside these constitutional structures. Something important to note is that at the founding, the original public meaning of the term reasonable was understood very clearly to mean the reason of the common law, and likewise, unreasonable was that which went against the reason of the common law. General warrants always went against the reason of the common law. And this is embodied by George Mason when he said, "We claim nothing but the liberty and privileges of Englishmen in the same degree as if we had continued among our brethren in Great Britain." So, really, few provisions of the Bill of Rights grew so directly out of the experience of the colonials as the Fourth Amendment. Embodying, as it did, the protections against the use of writs of assistance, but through the insistence on freedom from unreasonable searches and seizures as a fundamental right, gained expression to the colonies late, and as a result of experience. But there was also a rich English experience to draw on. Again, we go back to Cook, every man is his castle, uh, and the right of the homeowner to defend his house against unlawful entry, even by the king's agents. But at the same time, again, we do recognize the authority of the appropriate officers to break and enter upon notice in order to arrest or to execute the king's process. But most famous of the English cases was Entick v. Carrington, uh, and this case, as we saw, was one of a series of civil actions against state officers who, pursuant to general warrants, had raided many homes and other places in search of materials connected to John Wilkes, who was a polemical pamphleteer attacking not only government policies but the king himself. And Entick was an associate of Wilkes. That's how he got tied into it. He sued because agents had forcibly broken into his house, broken into locked desks and boxes, and seized many printed charts, pamphlets, and the like. And in an opinion sweeping in his terms, the court declared that the warrant and the behavior it authorized to be subversive of all the comforts of society, and the issue of a warrant for the seizure of all of a person's papers rather than only those alleged to be criminal in nature was contrary to the genius of the law of England. And besides its general character, the uh, the court said the warrant was bad because it was not issued on a showing of probable cause, and no record was required to be made of that which was seized. And with Entick v. Carrington, our own U.S. Supreme Court has said that that was a great judgment and was indeed one of the landmarks of English liberty. This is really one of the more permanent monuments to the British Constitution, and really a guide to understanding what the framers meant in writing the Fourth Amendment. Now, in the colonies, it was a little different because smuggling rather than seditious libel generally was what afforded the leading examples of the necessity for protection against unreasonable search and seizure. This was in order to enforce the revenue laws. English authorities made use of the writs of assistance, which were these general warrants that authorized the bearer to enter any house or other place to search for and seize, quote, prohibited and uncustomed goods, end quote, and commanding all subjects to assist in these endeavors. Once issued, the writs remained in force throughout the lifetime of the sovereign who issued them, and even 6 months thereafter. So when, upon the death of King George the Second in 1760, the authorities were required to obtain the issuance of new writs. Opposition was led by James Otis, who attacked such writs on what are really actually very libertarian grounds, and who asserted the invalidity of the authorizing statutes because they conflicted with English constitutionalism. And while Otis lost on his case uh, with the writs that were issued, his arguments were much cited in the colonies, and not only on the immediate subject, but also often with regard to judicial review. Something I kind of like to say about James Otis when it comes to the Paxton case is uh, James Otis may have lost his case, but in a very tangible sense, he may have won the war. And by which, of course, I mean the Revolutionary War. Although he did not live to see the end of it, and what eventually became the Constitution and the Bill of Rights and all of this, he still was just that integral in convincing the people of the importance of uh, uh, standing up for these natural rights. Uh, Now, here we see from James Otis. I took a great quote out of what may be possibly his most well-known and or most important treatise that he wrote called "The Rights of the British Colonies," written in 1764. And in it, he says, especially at a time when the finest writers of the most polite nations on the continent of Europe are enraptured with the beauties of civil constitution of Great Britain, and envy her no less for the freedom of her sons and for her immense wealth and military glory. But let the origin of government be placed where it may, the end of it is manifestly the good of the whole. Salus populi supreme lex esto is of the law of nature, and part of that grand charter given the human race, though too many of them are afraid to assert it. And right here in that one pregnant phrase, we see Otis appealing to the Magna Carta, to the common law, and to natural law, all in one very sort of uh, poetic pastiche that was very compelling. And he was of the belief that the ends of government, being the good of mankind, uh, would point out that its great duties is above all things to provide for the security, the quiet, and the happy enjoyment of life, liberty, and property. There is no one act which the government can have a right to make that does not tend to the advancement of the security, tranquility, and prosperity of the people. If life, liberty, and property could not be enjoyed in as great perfection and solitude as in society, there would be no need of government. But the experience of ages has proved that such is the nature of man, a weak, imperfect being. That the valuable ends of uh, men cannot live apart or independent of each other. In solitude, men would perish, and yet they cannot live together without contest. These contests require some arbitrator to determine them. The necessity of a common, indifferent, and impartial judge makes all men seek one, though few find him in the sovereign power of their respective states or anywhere else in subordination to it. Well, that is going to do it for today. I hope I was kind of able to uh, give you a good feel of the history of how we uh, got from natural right to natural law and this idea of right to privacy to a sort of constitutionalism where we ended up with a constitution that was really ultimately taken to be a fiduciary instrument, which is uh, largely the result of people like James Otis and the means in which they argued for the natural rights uh, of all people as they related to citizenship and to the law. So, again, thank you for checking the show out. I will likely be back on Friday with my conclusion to the 2A series that I've been doing. Please let me know what you thought down in the comment section below, and check out the video description for this video, where I will have links and citations posted for every single source that I used in putting together the information that I presented to you here in this episode. If you liked the show, I would ask again, please consider subscribing to the channel, especially over here on YouTube, to keep informed of new content as it comes out. Uh, and if you liked this episode, again, please consider sharing this episode with one person who you think would also enjoy it. So, this has been Categorical Imperatives with me, Lockie and Liberal, discussing the right to privacy and constitutional law. So take care, and as always, delenda est Carthago.